Imagine a doctor tells your family they want to remove life support for a family member, but you don't agree. The question is, can they do this anyway? This is the exact situation that happened in the case Cumberson versus Rassouli, and the decision changed how the concepts of treatment and consent work in Canadian healthcare with respect to withdrawal of life support. In this case, Mr. Rassan Rassouli was a patient in Ontario who was on life support after some complications from a surgery. His physicians believed that continuing life support would not improve his condition and said it was medically futile and could even harm him. For this reason, they wanted to remove life support, which they felt would be in line with the standard of care and ethical obligations of doctor. However, Mr. Hassan Rassouli's wife disagreed. She was his substitute decision maker, and she believed that there was some indication his condition while on life support might be improving, but also, if not, that removing life support would go against his religious beliefs. And she argued that treatment should continue, and she would not consent to the removal of life support and administration of palliative care. So, out of this, the key legal question became, do doctors need consent from the substitute decision maker to remove life support? Well, the case ended up going all the way up to the Supreme Court, and the court decided that yes, doctors do need consent from the substitute decision maker if the removal of life support in the circumstance is considered treatment under the Act. They ruled that removing life support counts as a form of treatment under Ontario's Healthcare Consent Act, in cases like Mr. Rassouli's, where removal of life support would require some physical contact with the patient to which consent was required, where it would require administration of treatment, in this case palliative care, and where death was imminent as a result of treatment. If a patient or substitute decision maker refuses, doctors cannot just act on their own to remove life support because it's considered a treatment, and they cannot force a treatment on anyone, even if they think the alternative of keeping the patient on life support has no medical benefit and contradicts their professional obligations. Once it is established that in these circumstances removal of life support is a treatment, then the existing statutory process should apply. If the doctor disputes the substitute decision maker's decision regarding removal of life support, the dispute must go to the Consent and Capacity Board, whose role is to decide what should happen based on prior stated wishes and the patient's best interests. The case does not apply to all circumstances, and the court made it clear that they were only deciding whether removal of life support is considered a treatment, in which case the existing Healthcare Consent Act would apply to preserve the right to consent. So, bring this into a more real-world setting, what does this mean for you or your family? The result of this case is that it strengthens patient autonomy, which means your right to make decisions about your own body and medical care. If you are unable to make decisions because you are incapacitated, if you have one, your substitute decision maker will speak for you and will follow your stated wishes and the patient's best interests. Implicit in this case is the importance of putting in writing any wishes you have in this regard for your authorized substitute decision maker. And because of this case, physicians cannot override your wishes easily. Patients and their families have a real legal voice, and disagreements about the continuation of treatments must go through a formal process, not just the doctor's judgment. This case also has a bigger impact on the broader healthcare system. It creates a balance between medical expertise and professional standards of physicians and patient rights. However, it also makes the system more complex, as now doctors have to deal with delays, sometimes continue treatment they believe is not effective, and go through legal processes. Specifically, they go to the Capacity and Consent Board to argue that the substitute decision maker is not following the best interests or prior wishes criteria set out in Section 21 of the Healthcare Consent Act for treatment-related decisions. An effect of this is that it can affect hospital resources and decision-making. And overall, the case shows that healthcare is not just about medicine, it's also about ethics, law, and respecting individuals' decisions. So, in conclusion, the Rassouli case tells us, even in life or death situations, physicians cannot unilaterally withdraw life-sustaining treatments from a patient without consent from the patient's substitute decision maker, even if the physicians deem the treatment medically futile. And that's important because healthcare decisions are not just medical, they're also personal.